Republic of the Philippines, GR number 170663. The parties of this case is Edison Saw, the petitioner, and the respondents, the Republic of the Philippines. The facts of this case is Edison Saw filed for a petition for naturalization under Common Law Act number 473, claiming to be born in the Philippines, of good moral, and having studied at UST. He complied with all the publication requirements and presented two witnesses, which is Attorney Artemio Adasa and Marcel Serro. The RTC granted the petition in 2003, but the Solicitor General contested it, claiming that the witnesses were not credible as is required for the naturalization process. The issue of this case is whether or not the people presented for SOS naturalization process are credible, and whether or not Edison Saw was entitled to become a Filipino citizen. The ruling of this case is no. The petitioner's credibility is not guaranteed due to the court's strict adherence to the law and high privilege status citizenship conferred by the Philippines. The interrogation of the witnesses were not enough to prove their morality, and their close relationship with the petitioner was unclear. Additionally, Edison Saw, or the petitioner, violated the naturalization requirement that it must be 21 years old and above who can file for the naturalization process. For that reason, we affirm the decision of CA denying for the petition for naturalization without prejudice.
And the first case digest that I choose, topic is Banks on the Third versus House of Representatives Electoral Tribunal, GR number 142840 on May 7, 2000. So the facts of this case, respondent cruised and listed in the United States of Marinos, and without the consent of Republic of the Philippines, he took an oath of allegiance in the United States. So as a consequence, he lost his Filipino citizenship and U.S. natural citizenship. So the issue is whether or not the Filipino citizenship would recover his repatriation, and the ruling is yes. In respondent Cruz's case, he lost his Filipino citizenship when he rendered service in the United States of Marinos.
So, good day everyone. This case digest about a citizenship. GR number 87193. The parties are Juan Dolanosa Ricardo versus a Comelec. The facts are petitioner Juan Dolanosa Ricardo was proclaimed a governor-elect in the province of Sorsogon in the due time of the League of Municipalities. Sorsogon chapter told the Commission on Elections and proclaim on the ground that he is not a Filipino citizen and having been naturalized on United States on January 20, 1983. The issue is whether or not the Pribaldo is a Filipino citizen on the time of the elections on January 18, 1988 as a provincial governor of the held a ruling. No, the collocation prescribed on the elected cannot be erased by the electorate alone. Hence, Ribaldo is not a Filipino citizen, therefore he is disqualified for serving as a governor of the
A pleasant morning to everyone. The case that I will discuss about is De Castro versus JVC, GR number 19160. Parties who were involved are Arturo M. De Castro, petitioner, and Judicial and Bar Council respondent. The facts of the case are the position of Chief Justice of the Supreme Court was to be declared on May 17, 2010. The Judicial and Bar Council had not yet submitted a list of nominees to the President. The petitioner Arturo M. De Castro filed a petition for certiorari and provision with the Supreme Court, arguing that the JEC was prohibited from submitting a list of nominees to the incumbent President Lorenzo Paganaroy because of the midterm appointments ban in Section 15, Article 7 of the Constitution issue whether or not the midterm appointments ban in Section 15, Article 7 of the Constitution applies to appointments to the judiciary. Ruling, the Supreme Court ruled that the ban on midnight appointments does apply to appointments to the judiciary. The court also held that the ban on midnight appointments is intended to ensure the impartiality and independence of the judiciary. So that's all.
A pleasant morning to everyone. My case digest is all about GR number 216771. Harold G. Ovalde, petitioner, versus Hall Conchita C. Morales in her capacity as the Here are the facts. The case revolves around Harold G. Ovalde, the procurement officers involved in obtaining police helicopters for the PNP, also known as the Choppers Camp. Ubaldo and others face administrative accountability for alleged dishonesty and actions against services best interests. The Court of Appeals upheld the decision of the Ombudsman, emphasizing the question of responsibility and actions against services best interests. And the issue is all about whether or not Court of Appeals erred in finding Ubaldo's administratively accountability for serious dishonesty and actions against services best interests. Here is the help or
Good morning, everyone. So the first case is titled Edison Saw versus the Republic of the Philippines, GR number 170604. So the facts about the case is in 2003, a naturalization petition is filed under Commonwealth Act 473 was approved by the RTC. However, the Solicitor General contested it, primarily questioning the credibility of the presented witnesses in the naturalization process. So the issue about the case is whether or not the presented witnesses are credible in SAW's naturalization process. So the issue or the rulings or decisions of the court is no. The petitioners bid for Philippine citizenship hit hurdles due to doubts about the witnesses' credibility and their connection to the petitioner. However, or additionally, the petitioner's age was the problem because the law requires a minimum age of 21 in the Naturalization Act.
So, good day everyone. This case suggests about age citizenship. GR number 87193. The parties are Juan Galanosa Ribaldo versus A. Comelec. The facts are petitioner Juan Galanosa Ribaldo was proclaimed a governor-elect in the province of Sorsogon in the due time of the League of Municipalities. Sorsogon chapter told the Commission on Elections and proclaimed on the ground that he is not a Filipino citizen and having been naturalized on United States on January 20, 1983. The issue is whether or not the Ribaldo is a Filipino citizen in the elections on January 18, 1988 as a provincial governor of the Sorsogon. Held a ruling. No, the collocation prescribed on the elected cannot be erased by the electorate alone. Hence, Ribaldo is not a Filipino citizen, therefore he is disqualified for serving as a governor of the Sorsogon.
Hello everyone, good morning sir, good morning classmates. The case digest number 1.HUC is 172 SRA 160. It's about the constitutional law and the both parties that are involved are President Aquino versus Mary Concepcion Bautista. In fact, in 1987, President Aquino appointed Mary Concepcion Bautista as the acting chairman of the Commission on Human Rights. In 1989, she was granted permanent appointment in discharge duties. Bautista refused to provide a document seeking a temporary restraining order from the Supreme Court. So the issue is whether or not Bautista appointment is subject to Commission on Appointment Confirmation or interim appointment. And the ruling is President Aquino can appoint executive official without the Commission on Appointment Confirmation, and interim appointment will remain valid until disapproval or Congress adjournment. And that's all for today.
Hey everyone, good day sir. My case digest is Republic versus Sabun, year number 187567. Facts of the case. Nora Sabun was a legitimate child of Albert Chan, a Chinese national, and Marta Borromeo, a Filipino citizen. She was born on August 8, 1959 at Baguio City and did not elect a Philippine citizenship upon reaching the age of majority. Issue whether or not Norma complied with the procedural requirements in the election of the Philippine citizenship. Ruling of the court. When the respondent was born on August 8, 1959, the governing charter was the 1935 Constitution, which declares as the citizen of the Philippines.
Good morning everyone. My first case is GR number 83820, May 25, 1990. Parties is Snar versus Comelec. Parties. I had a fact. Petitioner challenged respondent rights to hold public office on the grounds if the latter was an alien. Respondent maintained that he is a son of a Filipino, a holder of a valid subsisting passport, a continuous resident of the Philippines, registered voter since 1965. He was, however, also a holder of an alien registration certificate. Issue whether or not respondent is an alien. Held no, because by virtue of his being a son of a Filipino, it is presumed that he is a Filipino and remain a Filipino until it could be shown that he had renounced or lost his Philippine citizenship. In addition, possession of an alien registration certificate and accompanying proof of performance of acts whereby Philippine citizenship had been lost is not adequate for
Good morning, everyone. Good morning, sir. My title of the case is about 172 SERA 116. It's about constitutional law and the both parties are involved. Both is the first, the President Aquino. The facts are 1987, President Aquino appointed Mary Concepcion Bautista as acting and the chairman of the Commission on Human Rights. In 1989, she was granted permanent appointment and discharged duties. Bautista refused to provide documents seeking a temporary restraining order from the Supreme Court. And the issue is whether or not Bautista is a subject to mission and confirmation or ad interim appointment. And the ruling is the President can appoint executive official without no confirmation or ad interim valid until disapproval or Congress approval.
Good morning. My first case digest titled Lazar versus Comelec, GR 83820. The facts are, in this case, at bar, petitioner challenged respondent right to hold public office on the ground that the latter was alien. Respondent maintains that he is a son of a Filipino, was a holder of valid subsisting passport, a continuous resident of Philippines and registered voter since 1965. Also a holder of alien registration certificate. The issue is whether or not respondent is an alien. Ruling of the court is no, because by virtue of being a son of a Filipino, it is presumed that he was a Filipino and remained a Filipino until the proof could be shown that he had renounced or lost his Philippine citizenship. In addition, possession of an alien registration certificate unaccompanied of the performance of act.